Good afternoon, everyone, and welcome to HCR's latest COVID-19 webinar. Prynawn da, croeso pawb. This is our third webinar around COVID-19 and its impact on the workplace. Our first webinar was about COVID-19, focusing on business interruption insurance, contractual issues like force majeure and the like. And then recently we held our second webinar on return to work about 3 weeks ago for our clients who are based in England. And today, this is our third COVID-19 Return to the Workplace webinar, which is specifically focusing on workplaces based in Wales. Firstly, our first speaker will be Andrea Thomas, who is an employment law partner in our Cardiff office, and she will be speaking about the Coronavirus Job Retention Scheme, CJRS or Furlough, which is changing from the 1st of July onwards to include employer contributions and flexible furlough. And then she'll give us an overview of the guidance and statutory requirements which employers in Wales need to follow as their employees are returning to the workplace. Secondly, I'll hand over to Bryn Thomas, who is a licensing, regulatory and tax partner in our Cardiff office, and he will be highlighting some of the main duties employers have under the Health and Safety at Work Act 1974 and other key health and safety regulations. He'll run us through the key provisions of the workplace guidance, look at the Health Safety Executive and COVID risk assessments, and also review regulation and enforcement in the current climate. And then last but by no means least is our third speaker, Chris Mayers, who's a partner and head of our employment team in our Cardiff office, and he'll be speaking about the reluctant returner to work and whistleblowing, mediation and the like. If you have any questions, please do submit them through the Q&A section on the webinar. Please keep them coming in. I can see a few questions have come in so far. So as we proceed, please do ask questions. Andrea Thomas is a native Welsh speaker, so if you'd like to ask questions in Welsh, please feel free to do so. To keep proceedings flowing, because it's a webinar rather than a face-to-face, we will deal with a Q&A at the end of the session. But please feel free to ask questions as they come through and we'll try and group them or answer them individually. If any questions come through that we're unable to answer this afternoon because of timings, then we will agree to answer those questions individually to you after the webinar. And we will also collate the answers that we've submitted and dealt with this afternoon and circulate them after today's webinar within a few days. So let's get the ball rolling and start with our first speaker, Andrea Thomas, employment partner, who is covering employment law considerations on furlough changes in Wales and guidance for employers preparing for return to the workplace. Over to you, Andrea.
Thank you, Nicola. Thank you, Nicola, and good afternoon, everybody. I'm going to be talking about two things: flexible furlough, and the changes coming in from the 1st of July. And also I'm going to be talking about the workplace guidance as it applies in Wales. If I could have the first slide, please. Right, from the 1st of July, flexible furlough is going to be coming in. And then from the 1st of August, there are going to be some changes to the grants available to employers. Now, this isn't exclusive to Wales. It applies to both England and Wales. But because I know it's important to a lot of people, I am going to look at the furlough scheme as well. Now, from the 1st of August, employers will have to pay national insurance pension contributions and pension contributions up to the statutory minimum themselves. Previously, they could reclaim that from government. Then from the 1st of September, it will change again so that employers have to contribute 10% to the payment made to their workers, so the grant reduces to 70%. Then from the 1st of October, employers have to pay 20% so that the grant reduces to 60%. And to avoid any doubt, employers will have to make up the difference, so they have to pay the national insurance contributions, the pension contributions, and the balance up to 80% or a cap of £2,500 per month. Then the scheme will close altogether on the 31st of October. What then for employers? Well, as these changes come in, the impact on employers, unfortunately, is going to increase. The furlough scheme has been a cushion up till now, but that is gradually going to reduce. So employers who are still badly affected by the pandemic, whose businesses have still not returned to anywhere near normal, unfortunately are likely to have some decisions to make. It's been estimated that for the average employer and the average claim, a 10% contribution is going to be £207 per head, and then a 20% contribution will be £345 per head per month. So that is going to make a significant difference to those people with large payrolls, and employers may have to look to see how they reduce that. That may mean reducing hours or reducing pay, or unfortunately in some cases redundancies. We've seen today that a large Welsh employer, Castell Howell Foods, has unfortunately announced that it is commencing redundancy consultation. Now those are really big topics, and unfortunately I'm not going to be able to cover them today. But the only thing I would say is, if you think you're going to be in that position, then please do allow yourself enough time to work through these things, particularly if the collective consultation regulations are going to be engaged, because there are statutory minimum type periods which you're going to have to comply with. Could I have the next slide, please? Right, if we look now at the changes from the 1st of July, that is when flexible furlough will come in. Up till now, you've had to claim for periods of at least 3 weeks per employee. And when those employees are furloughed, they are not allowed to do any work at all for you. Now that's going to change in that from the 1st of July, employers can bring back employees for any length of time and for any work pattern. The employer pays for the hours or days worked, and that has to be at the employee's normal pay, but they can claim a grant for that percentage of time when the employee is furloughed. Now, when the employee is actually furloughed, the normal rules still apply in that they're not allowed to do any work during that period other than training, and also that there should be written confirmation of the agreement that's been reached between the employer and the employee. The furlough scheme closed to new entrants on the 10th of June, so that the last 3-week period would have run from the 10th of June to the 30th of June. And you're not actually allowed to claim for anybody who's not been previously furloughed for a 3-week period up to the 30th of June. So you can't furlough anybody new from the 1st of July onwards. Now, the exception to that is people who are returning from statutory maternity or paternity leave, or indeed any form of statutory parental leave. You are still able to furlough those people after the 10th of June. Now, the furlough agreement itself can be for any length of time, but HMRC have stipulated that each claim period has to be for at least 1 week, and from the 1st of July onward, each claim period must start and end in the same month, and that is because the scheme will be changing from month to month. So if you're furloughing somebody, say every Monday and every Friday, you can only put in 1 claim per week. And actually you're encouraged not to put in a claim at all until you know how many days in each month an employee will be furloughed, because if you overclaim, then HMRC are unfortunately going to make you pay that money back. There is another proviso in that the number of employees you claim for in any one period from the 1st of July onwards cannot exceed the maximum number of people you had on furlough at any one time prior to the 1st of July. So if you were hoping to furlough your whole workforce, say for 1 day per week, to share the burden, then you're not going to be able to do that unless you've previously furloughed your entire workforce at the same time. You're still going to be able to rotate staff, but obviously that will be a bit more complicated for you to administer. Now that's all I'm going to say about the furlough scheme. I appreciate it's a big topic and there's a plethora of different guidance on it set out in a number of different documents. So if anybody's got any questions on that, then please do submit them, or alternatively, if you want more information, I'm very happy for you to contact me afterwards. If I could please have the next slide. Right, I'm now going to turn at the guidance as it applies to Wales. As many of you will realise, I'm sure, the guidance in Wales is considerably different to that in England, and the guidance applying to workplaces is no different. Of course, following the Prime Minister's announcement lunchtime today, the guidance in England and Wales has separated even further. Now, insofar as the guidance applying to workplaces is concerned, I'm going to look only at the key documents. Now, the first one is the Health Protection Coronavirus Restrictions Wales regulations, and that is the one that sets out a statutory duty to take reasonable measures to ensure workplace distancing of at least 2 metres. And the important thing to remember about that it is a statutory obligation, and a breach of that can result in criminal sanctions. Now, there is statutory guidance which accompanies that. It is statutory guidance, which means there is something that has to be followed rather than being something which you should aim for. My colleague Bryn is going to look at that in a bit more detail as part of his presentation. Now, there is also workplace guidance called Keep Wales Safe at Work. That is not statutory guidance, but nevertheless is an important document that sets out 5 key principles and deals with things such as risk assessments, which again, Bryn is going to look at as part of his presentation. The point that I wanted to emphasise is that in the guidance, the emphasis in Wales is still very much on working from home, unless that's not reasonably practicable. And indeed, that's something that applies in the statutory guidance as well, which says that first of all, you look at whether people can work from home, and it is only when that's not possible that you can then move on to looking at the kind of adjustments you need to make to the workplace. The obligations on employers to facilitate home working is really quite onerous. For example, employers should look at things like supplying laptops and mobile phones to facilitate home working. And for those groups that are particularly vulnerable, then they should also look at things like whether alternative roles may be available that can be done from home if people are not able to do their normal job from home. So that is really quite an onerous obligation. If I could have the next slide, please. Now, on my final slide, I'm just going to touch on some of the other guidance. First of all, the manufacturing protocol. And if you work in that particular sector, that really is an important document, and I do urge you to look at it. It sets out some quite detailed provisions, guidance, and also practical steps about ensuring safety in that particular setting. There is also quite a detailed flow chart at the back of the protocol, which sets out the assessment process where you have vulnerable employees, and that covers not only people with clinical conditions, but also other factors that may make them more vulnerable. And you need to look at people not just those ones in terms of age, for example, who are over 70, but also people who are over 60. So that does set quite a high standard for employers. It is aimed at the manufacturing sector, but it does say that it can also be adapted for other sectors. Now, there are other sector-specific guidance documents out there. Those are not exclusively employer guidance documents, but they do contain employer provision. So it's also important to look at whether there's any applicable documents in your sector. There is guidance in things like sport and leisure, public transport, more recently retail, and also holiday accommodation. The holiday accommodation is quite sparse at the moment because, of course, those places are still currently closed, and although we would hope to get more detailed guidance in the coming weeks, although I have to say that the retail guidance was only updated on Sunday, where the shops in Wales actually opened on Monday. The other thing I wanted to touch on is the Trace, Track and Protect guidance for employers, and that sets out how employees can be tested if they have symptoms, and also some guidelines for employers in dealing with the consequences. The point I wanted to emphasise is that you should really think about the potential impact of that on your business. The likelihood is that a lot more some asymptomatic cases will be picked up by that process, and we've seen that very recently in the outbreak in Anglesey in the Two Sisters meat processing plant. That has implications for you as an employer, because it means that anybody who tests positive, their contacts may have to isolate for 14 days. And of course, that can happen in the workplace. So if you have people in the workplace who test positive, then colleagues who work closely with them may have to self-isolate for 14 days. Do think about how that is going to impact you in terms of how you plan your workforce and what people come in at the same time, and also whether it's a good idea to have different groups of people working together at the same time. Also think about what you're going to pay them if they are forced to self-isolate. They are entitled to statutory sick pay now. The regulations have recently been changed, but the guidance does actually urge you to pay them in full if you're able to do so. But of course, in the current climate, it's quite possible that a lot of employers will not be in a position to do that. I also wanted to touch upon PPE. Now, the current guidance from Welsh Government is that it's not necessary to wear PPE as a means of reducing the COVID risk outside the clinical or social care sector. Of course, if you wear PPE, that's personal protective equipment for anybody who doesn't know. As part of your normal job, you should of course continue to do that. However, there is now some guidance from government that the use of face masks may be useful in environments where people are not able to keep a distance of 2 meters. So that is very lukewarm guidance, it's got to be said, but that is something else for you to consider in the round. You shouldn't obviously use that as an alternative to workplace distancing. Now, Bryn is going to look at consequences of not complying with the guidance in terms of criminal sanctions. Chris will look at potential employment claims. The only other thing I wanted to mention is the potential for civil claims as well, if people are able to establish that they wouldn't have caught coronavirus were the guidance followed. So unfortunately, that is just something else for you to bear in mind. Now, that is all I'm going to say for today. I will hand over to Nicola in a moment. As I said, please let us have any questions, or please contact me if you require any information. Thank you for joining us today. Diolch yn fawr.
Thank you very much, Andrea, for your thoughts and recommendations there on furlough and the statutory guidance in Wales, and some food for thought as well on how businesses progress with those complex issues. There are thankfully lots of practical tips and ideas that you've given there, but also some questions that I think will need some further thought and consideration. So let's move on now to Bryn Thomas, who's licensing regulatory partner. He will be talking about health and safety in the workplace and walk us through some practical steps to ensure a safe return to work for your employees and visitors and other contractors when on site in Wales. Bryn, over to you.
Thank you very much, Nicola, and welcome everybody. So, in terms of the health and safety landscape, it's important, obviously, to look at the context, and we're all striving towards less infectious workplaces, obviously. As you see on the slide there, it won't come as a surprise. I set out the fact that employers have a clear duty to protect the health and safety of their employees whilst at work. And also there's a reciprocal duty on employees to take reasonable care, obviously, for their own safety. Now, one of the government's main aims or priorities is to assist employers and their employees to return to a safe workplace as soon as possible. But it's important to look at the fact that the potential for exposure to risk must be carefully controlled indeed. Employers have obligations under the Health and Safety at Work Act 1974 to take all reasonably practicable steps so as to ensure the health, safety and welfare of workers and anyone else impacted by operations. And that will include keeping up to date with work-related risks posed by COVID, as well as planning and implementing all reasonably practicable risk reduction measures. And we must bear in mind the fact that, as has been alluded to by Andrea, breach of the Health and Safety Work Act is a criminal offence. Next slide, please. So, in terms of the specific public health legislation that we have in Wales, it's the coronavirus restrictions regulations, and in Regulation 6A, that is the key one, that sets out the statutory duty to take all reasonable measures to ensure that the distance of 2 metres is maintained between persons on premises, and failing to comply with that without reasonable excuse is an offence, and it can lead to a fine on conviction. In respect of Regulation 7A, we have the guidance that's been issued pursuant to that, as Andrea has alluded to, and that relates to the steps necessary for taking all reasonable measures to maintain physical distancing. And if I can just walk you through the main provisions of that. Obviously, general message is to work from home if possible, and physical distancing is intended to supplement a range of other actions being taken to minimise risk. Every employer who can achieve workplace distancing is expected to do so, but it's not an absolute requirement. It's recognised that there will be some workplaces where it is not possible. The most effective way of ensuring physical distancing is to enable some or all staff to work from home, some or all at the time. And our reasonable measures includes an expectation that employers should be as flexible as possible and make adjustments wherever that is possible, and that includes issuing laptops and mobile phones to facilitate home working. There's no hard and fast rule on what is reasonable, but the test is objective, and considerations obviously include cost, nature of work, and whether the measures might affect the health and safety of others, and the nature also of others in the workplace, in particular, say, children or vulnerable adults. Examples of the measures would include reducing the number of people on the premises, staggering shifts, increasing distances between workers, and also marking out spaces and increasing space available for rest breaks, etc. Next slide, please. So, the COVID-19 risk assessment, the all-important risk assessment, really, it's acknowledged by all that a return to the workplace brings with it an increased risk of transmission. That's in no doubt. The 2 metre rule and other measures are no guarantee against the virus spread. And that's actually shown by recent modelling conducted by the Finnish Meteorological Institute, and that demonstrated actually that a particle spread from a single cough extended over a distance of tens of metres in all directions within only 2 minutes. So the Welsh Government advised that no work should start without an up-to-date risk assessment in place. Now, as part of the planning, or as part of looking at a stepwise resumption of operations in the workplace, it's necessary, obviously, to follow the government's rules and any revisions to those as they're relaxed, as we are now seeing. To comply with health and safety criminal law, it will be necessary to revise, renew, and create your risk assessments dealing with COVID to encompass returning to work. And your COVID-19 return to work plan must identify the hazards and set out the mitigation measures that are required. More specifically, you have Regulation 3 of the Management of Health and Safety and Work Regulations 99, and that states that you have to make a suitable and sufficient risk assessment of health and safety risks to those affected by your operations. It's really important to make the point here that a risk assessment, there's no point in going for an off-the-shelf generic one. It has to be bespoke, it needs to be specific, it must identify the risks, because that's what is going to be considered in the event, the worst case scenario event of an infection arising. Risk assessments must be in writing if you have 5 or more employees, and they must be reviewed and updated. Circumstances are obviously changing fast with COVID, so it's important to keep abreast of the developments and act accordingly. And finally, there are provisions under the Personal Protective Equipment at Work regulations as to provide suitable PPE, and that includes PPE that must be appropriate to prevent the risks and adequately control it. And that includes giving employees adequate information, instruction and training regarding the use of that. And that equipment needs to be maintained, cleaned and replaced as appropriate. Next slide, please. So the Health and Safety Executive, they are going to play, or that body will play, a very important role in policing social distancing in the workplace. It's said that it's going to carry out spot checks, and it's been given a substantial budget to do so. So essentially the message is be warned and be prepared. If you comply with the relevant workplace guidance, though, they're likely to be able to demonstrate compliance with the reasonable measures. Now, the HSE has said that deaths due to COVID are RIDDOR reportable. RIDDOR is the reporting of injuries, diseases and dangerous occurrences regulations. And that states that an unintended incident at work which has led to someone's possible or actual exposure must be reported as a dangerous occurrence. And a worker who has been diagnosed as having COVID, if there's reasonable evidence that it was caused by exposure to work, that must be reported as a case of disease. It's actually interesting in respect of causation to look at the link between, say, an infection, an example of an infection or an incident, and the workplace, and that link. It may actually be quite difficult for a suitably qualified medical practitioner to attribute COVID-19 to an actual strict occupational exposure as distinct from an exposure within the wider community. However, clusters of confirmed cases arising in a single business are bound to lead to a presumption that the exposure has, on balance, occurred within that workplace, and that there will be questions will be asked. Next slide, please. So, in summary, fundamentals really. You need to engineer out the risk and add your mitigation, as I've said. The most effective control in terms of elimination, of course, is not really within our gift. It's a virus, and only a vaccine is going to prevent the most severe symptoms and eliminate that. So we need to focus on reducing, innovating and controlling. The reopening of business premises obviously is not going to happen overnight. And once you've made your premises safe, the staff need to feel obviously comfortable and assured in returning to the work environment. It's about engaging employees. It's very important, fact versus perception. So for a healthy return, you need to support your employees and engage and communicate with them. And they need to obviously be advised on the risks. Also, it's important to account obviously for changes in behaviour. People may become more suspicious or more impressionable, and above all, they will be less willing to engage with anything that seems foreign or strange. culturally, organisations should be prepared for the shift that is going to come in terms of reintegration issues. Remote working is obviously going to provide a push for just further remote working. So you need to plan for that change in behaviour. And you have to adjust to make decisions quickly, assisting the migration of staff. And I think it's very important here to just say that you need to amplify the things that are working and which are positive and which are promoting the environment, like agile working and decision making at a pace, and then let go of those aspects which are clearly negative and not working, not suitable for purpose in essence. Last slide, please. So in terms of some concluding remarks, as I've said, mitigate against regulatory action and the claims. It's important to lean into the issues and essentially tackle them head on. It's about front loading this really. And we must remember that no one is obliged to work in an unsafe work environment. And indeed, one reason why the Welsh Government has decided to go beyond guidance and include this specific statutory duty in law, which they don't have in England, is so that enforcement is possible and that it essentially has teeth where it's necessary. Because we have to remember that ultimate responsibility lies with the business and its directors to assess the risk to health and safety. But we must remember, obviously, help is at hand. If not at Harrison Clark Rickaby's, there's a wealth of information, guidance and support literature and material online, and that should certainly give plenty of pointers to business in terms of what the minimum requirements are to combat the current situation that we're all experiencing in terms of getting the economy back on track. So thank you very much. Back to you, Nicola.
Many thanks, Bryn, for your summary of the regulatory framework and steps to take in safe return to the workplace in Wales, and practical tips and recommendations in risk assessments and risk management. Do please keep your questions coming through. I can see some great questions coming through, and we had some pre-submitted questions as well. So I think we'll have a lively Q&A session after our last speaker. Now I'd like to pass over to Chris Mayers, who is our last speaker. He is an employment partner and head of employment in our Cardiff office, and he will cover the reluctant returner and whistleblowing and tribunal matters. After that, we'll move on to the Q&A and we'll be ready to finish by 4 o'clock as planned. Over to you, Chris.
Thank you, Nicola, and good afternoon, everybody. Can I have the first slide, please? What I want to do here is just discuss with you for 10 minutes or so the problems that we've already identified and the problems that we expect are going to occur, particularly in the employment arena, and the sort of claims that are likely to proliferate as a result of this pandemic. As I say there in the first slide, returners, people who are out of the workplace at the moment, but will be returning at some stage. They may be reluctant, they may be frightened, or they may just be plain unwilling to return. So it's a challenge for employers to handle this situation sensitively, to ensure that they get their workforce to return if it's appropriate, and equally to ensure that they don't end up having to contest claims by any employees who are not happy about returning or who actually simply refuse to return. Clearly, what employers are going to have to do is they're going to have to adapt the workplaces in line with the guidance that Andrea and Bryn have referred to, having a particular regard for the health and safety aspects. And it will also be necessary for employers to adapt any existing workplace policies to comply with the Welsh Government guidance and the workplace distancing requirements, which at the moment are still at 2 meters in the workplace, together have a regard with any sector-specific guidance. So not only do employers have to demonstrate that they have adapted the workplaces and they have adapted workplace policies, but they will need to demonstrate that they have complied with the guidelines, and they will need to demonstrate that any request to any members of the workforce to return to work is an objectively reasonable one. Because of course, an employee, for a whole variety of reasons, may be, as I say at the beginning, be reluctant, frightened or unwilling to return. So the test is going to be whether a reluctance or a refusal amounts to an objectively reasonable one. Can I have the next slide, please? So as I say there, employers are going to have to demonstrate improved compliance with the guidance. And there's just some practical steps there. written risk assessments are obviously going to be a very good idea. And as Bryn has said, there's a requirement in certain circumstances to have written risk assessments anyway. But whatever the size of your workforce, we would certainly advise that you should carry out written risk assessments, so that if months or years down the line there's a challenge as to what was said, what was notified to employees, what considerations were taken into account by an employer, there will be a written risk assessment to provide contemporaneous evidence. If there's consultation with staff representatives, again, get that in writing. Ideally, get it agreed with the staff representatives or the trade union bodies, so that everybody is clear now what's been discussed and what's been agreed. If you've got a very large workforce, you might consider it appropriate to commission reports from independent consultants, so that you can demonstrate best practice with the very latest guidance in combating this public health scourge. The third point there, I've seen it already with some employers, I've seen it with our firm, that it's a very good idea to try to reassure staff by letting them have photographs, letting them have video footage, give them a walkthrough. Which way are you going to into the building? Which way are you going to exit? How can you get to the T point without there being a bottleneck? How do you get to the toilets without impinging on the social distancing requirements? Obviously, signage is a good idea. We've all seen it on the floor, on the walls, everywhere else. Hand sanitizers should be everywhere. And as Bryn and Andrew have mentioned, in certain circumstances, there should be PPE, and we certainly can deal with that when we come to the Q&A session. As a conscientious employer, you might have to consider whether it's appropriate to alter hours of work or changes to office location. If you're an employer with multi-offices, it's probably sensible that you don't have employees for the time being going to more than one location. They should have a designated base for the duration of this pandemic and stick to that, and really only go to another office if it's absolutely necessary. And I've said there, another consideration for larger employers is whether it might be appropriate to arrange transport to work. A large concern and reluctance by a lot of employees at the moment seems to relate to using public transport to get to work. If it's commercially justified, some employers might think, well, actually, we'll arrange a minibus or a coach, and people can have 3 seats each or whatever. But it's just a consideration that can be made by employers. Can I have the next slide, please? Again, it's important, as I say in the first bullet point there, that the employers are going to have to demonstrate how those new rules are going to be enforced. As Bryn in particular has said, the health and safety obligations, the health and safety duties are non-delegable. They are the employer's responsibility, and the employer cannot just sit back and say, well, some employees are going to comply with the guidelines, some others aren't. We've all seen some people, whether it's in a shop or out in the public, who seem to think social distancing is over. It's not. It might be relaxed slightly, but employers are going to have to demonstrate how they are going to ensure that any employees who are taking a laissez-faire attitude to this can be brought back into line for the good of their colleagues. What we are going to see, undoubtedly, and it's already started, is a proliferation of complaints based on health and safety and whistleblowing. And for those of you who don't deal with employment issues, it's important to bear in mind that in relation to health and safety issues, or for making a public interest disclosure, what's colloquially known as whistleblowing, employees are entitled not to be subjected to a detriment or to be dismissed for having raised health and safety concerns or for having blown the whistle. I'll deal with that a little bit more in the next slide, but the other point to consider here is that for any employees who qualify as disabled within the definition of the Equality Act, the employer is under an obligation to make reasonable adjustments in any event. A further extension of that is that there may be what's known as associative discrimination, and this is an area of law that's still under development, but most of you will know that normally claims of discrimination relate to the fact that you as a claimant have been discriminated against on the grounds of a protected characteristic, of which disability is one. But that can be extended so that if an employee considers they've been discriminated against on the basis that they live with, for example, somebody in their family who is shielding, or somebody who is particularly vulnerable in some other way, then that may extend the protection beyond the normal disability discrimination. And the final point I've made there is that all of these are what are called day one rights. So the employees who come within the definition of a whistleblower, or who are disabled, or who may be entitled to claim associative discrimination, can claim these protections from day one. Next slide, please. So I think we've gone backwards, haven't we? Sorry, next slide. Thank you. Right. In relation to health and safety issues, the test, as Brynna said, is whether there is a serious and imminent risk. That's going to be the test for any employee who wants to bring a health and safety claim in the employment tribunal. And of course, it's not going to be the largest hurdle they've ever encountered to persuade a tribunal that, given the numerous government statements and the fact it's a global pandemic, to indicate that any reasonable, objectively justified concern is a serious and imminent risk. I've made a point there that we've recently been asked on, is whether employers can request an employee to sign a waiver or an indemnity before allowing them to return to work. The sort of thing that you might see in a theme park that says you go on this ride at your own risk. It would be entirely inappropriate, in my view, for an employer to suggest that an employee should sign a waiver or an indemnity before allowing them to return to work. Whilst it's appropriate that the employee should be reminded of the risks and the guidelines, etc., it's not appropriate to get them to sign a waiver because, as I've already mentioned and as Brynna said, the duty on the employer is non-delegable. It cannot be delegated, so it would be inappropriate. Next slide, please. Okay, I've said there's likely to be a proliferation of whistleblowing and disability claims. And again, for those of you who are not versed in employment law, if you can demonstrate that a dismissal was on the grounds of whistleblowing or in relation to disability, then it can be automatically, it can lead to a finding of automatic unfair dismissal, unlimited compensation, and as I've already said, it's a day one right. There's no qualifying period. So if you do have discussions with individual employees about any concerns they express about a return to work, then please do take a very careful note of what's said, what's being discussed, because then you might be able to defend a whistleblowing claim if one is made. Right? The second point I've made there is that, of course, you might have some people in the workforce who, at the time they were furloughed, were not known to have disabilities, but they may actually have developed problems during the period of furlough. It's well documented that some people are suffering with mental health issues, and I've set out there that anxiety, depression, or an adjustment order, which might be due to isolation, to bereavement, domestic abuse, stress, or other triggers, might, in certain circumstances, amount to a disability. And therefore, you have to be very careful that they are not, that any action you take is not considered to be in relation to that disability. All right? So my final 2 points there is I've indicated there are many opportunities for a reluctant returner who wishes to stay at home. If your view objectively is that they genuinely don't want to come into work because they have a sincere belief about their concerns, then of course agreeing unpaid leave will always be an option for the employer to consider. Right? So hopefully that's given you food for thought from the three of us speaking this afternoon. We're very happy to answer any questions. We've already seen some on the screen. So I'll hand back to Nicola now to mediate on those particular questions.
Thank you very much, Chris, and thank you for your detail there about the reluctant returner to work, very helpful. So I think we've got approximately 12 minutes for questions. If we're unable to answer all the questions this afternoon, we will follow up after the session and we will be in touch with you individually. So I can see there's quite a few questions come through live. I'll try and deal with the live questions first. So if I may come to Andrea with the first question. If my business is based in Wales, but my workforce delivers services both in Wales and across the border in England, which rules do I follow?
Thank you, Nicola. That's actually a really good question, and I'm afraid the answer's not entirely clear. The guidance in Wales and England is entirely different. The guidance that applies in England states quite clearly that it does not apply in the other devolved nations. So strictly speaking, whilst you're in Wales, you follow the Welsh guidance, and whilst you're in England, you follow the English guidance, and that's not particularly helpful to any employer, I appreciate. But I think perhaps the pragmatic answer is that the guidance in Wales is probably more onerous than the guidance in England. So if you follow the Welsh guidance, I don't think you will go far wrong. And in particular, the Welsh guidance imposes a statutory duty which will apply for as long as you are in Wales, although arguably that would cease to apply once you cross the border. But it just illustrates that the two nations don't, live in isolation, and people cross the border all the time for various reasons, including work. And this is an obvious problem with having different guidance in England and Wales. So I'm not sure if that helps, but I
think it's a very poignant question, very helpful, thank you. Can you take another one, please, Andrea? They're coming through quickly. I've got one on, can my employees insist me on giving them face masks to wear in the office? So related to PPE.
Okay, no, I don't think they can, unless you work in an industry where you would normally wear face masks as part of your normal PPE. So purely as a means of dealing with COVID risk, I don't think you can. It doesn't apply in the workplace guidance. There is a separate announcement from Welsh Government applying to everybody, not just employers, which says that there is some evidence that they do help with the transmission risk if you're not able to distance by 2 meters. So the first step is to maintain 2 meter distancing if at all possible. The guidance does recognise, and as Bryn's discussed, that there may be situations when that's not always possible. So in those circumstances, perhaps it's something you might want to consider, if only for the fact that it may make employees feel better. But certainly I don't think it's something that can be insisted upon, definitely not in an office environment, and you should be maintaining 2 meter distancing if at all possible.
Thank you very much. And one further question, please. Where can I get the risk assessment guide for manufacturers from? I assume that relates to the manufacturing protocol you mentioned.
Yes, that is actually part of manufacturing protocol. There's a section on the back which deals with that. The manufacturing protocol is part of the Welsh Government's suite of documentation for employers on COVID-19. If you go into the Welsh Government website, into the COVID-19 guidance, there is a separate section for employers, and then it's part of that section. But if the person who asked a question wants to contact me afterwards, I'd be very happy just to send a link through.
Thank you, Andrea, very helpful. If I can move on to Bryn, please. Bryn, I've got a couple of questions here for you. One is, are you saying as an employer I have to give my employees a work phone and laptop?
No, I'm not, and that's the short answer. Apologies if I gave that impression. You don't have to do that. It's about taking reasonable measures. You've got to look at the nature of the work, the cost involved, how many employees that you have. But if you're making a business decision on cost grounds that it's not possible, then the emphasis is to work from home if at all possible. So you should facilitate that as far as you possibly can. If you can't do that, and an employee finds himself in work because they have to work and be in the workplace to conduct their role, then it's all about taking of reasonable measures to ensure that they can do that as safely as possible. So in short, no is the answer. You don't have to provide that.
Thank you, Bryn. And one further question. Who decides whether my risk assessment is good enough? if I have to bespoke it to my office, surely I'm the best judge of what is appropriate.
Good question. Essentially, yes, you are best placed to decide about a risk assessment and a bespoke one to the office in terms of the nature of the undertaking, the employees that you have and the work environment that you're dealing with. You just have to bear in mind that, worst case scenario, there could be scrutiny by the health and safety executive if you get instances of COVID which arise and they're proved to be through the workplace environment. Your risk assessment has to stand up to scrutiny. There are a lot of risk assessments online, but they're generic in nature and off the shelf. As I've said, I'd move away from that as far as possible. But if any conscientious employee will look at all the proper issues that they've got to consider and factors, I'm quite sure, as you said, I agree that you're best placed to decide that. And if you've looked at all the issues, I'm sure that that's going to satisfy the regulatory bodies and any focus that's placed on the business by the health and safety executive.
Thank you, Bryn. Coming back to the live questions, I've got one more live question here, which I'll put to Chris if that's okay. So Chris, this is a director's duties question really. It says, what can I do if my fellow directors don't agree with my proposed measures for making our business safe?
Right. Well, the obvious pragmatic answer to that is, well, first of all, I don't know how many directors are involved, and I don't know whether any particular director has assigned to him or her responsibility for health and safety. Clearly, the best way forward is to try and achieve consensus between the directors. If not, and the director who's asked the question is concerned that he or she is being pushed down a route that they're not happy with, then again, it goes back to my fundamental point. They need to document that very, very clearly. And certainly my experience is that if it gets to the point where a director or a senior manager says, I am not happy about this, I am putting in writing my concerns, my objections, then that quite often will grab people's attention and focus their minds. Because as Bryn has said, there's very serious consequences for breach of health and safety duties. So start with trying to get consensus. If you can't, then I would certainly document it to safeguard your point of view as the director who seemingly is in the minority.
Thank you, Chris, very helpful. Can I move to Andrea now and ask a question about redundancies? So if I need to make redundancies as the furlough scheme winds down, when should I start thinking about it?
Right, I mean, the simple answer is as soon as possible. I mean, there will be some employers who generally don't know at the moment whether they're likely to make redundancies. If they're now allowed to reopen, say, shops, for example, retailers are the obvious example. They really don't know until they start how badly affected their business is going to be. There will be other businesses, for example, hotels, whilst they are hopefully going to be able to reopen in 3 weeks' time to some degree. It's highly unlikely that parts of their business, for example, the conferencing or weddings, for example, is going to be able to restart for some time. For those people who really know at this stage that they're going to have to make redundancies, then I think they should start planning for that as soon as possible. Unpleasant, although that is, in particular, if you are going to make 20 or more people redundant within 90 days on the same site, then the collective consultation obligations are going to be triggered. You also need to notify the Secretary of State. Between 20 and 99 employees, that is going to be a 30-day period. That's your absolute minimum. And for 100 above, it's going to be 45 days. Again, that is an absolute minimum. So it is important that people start to plan for that as soon as they know that that's going to be likely.
Thank you, Andrea. Can I move on to Bryn and ask a question about the Two Sisters and food packaging and food preparation businesses? Because there's been some concerns about the ability to maintain that 2 metre distancing in those industries, and I was wondering what your thoughts were there, because there's clusters and proliferations of COVID-19 in those environments.
Yes, thank you, Nicola. Yeah, it's been very interesting what's been happening over the last few days with regard to the meat processing plants and abattoirs and that particular industry. I mean, it's obviously not just a Welsh phenomenon, it's happening across the board. We've got 2 instances, I think Wrexham and Anglesey, and then there's 1 or 2 cases of facilities in Yorkshire and elsewhere in England. But it's interesting because there are quite distinctive characteristics of those environments which are kicking off these clusters. I think there was quite an eminent professor from Liverpool University who basically stated that if you look at the environment, it's dark, it's cold, there's good aeration through there, you've got plenty of employees working on factory lines and conveyors, it's difficult to socially distance, you've got communication issues with masks, it's a very difficult working environment. So, you know, there's a clear focus on that at the moment. And it's going to be very important for the owners and people running those businesses to focus on the risk assessment side and to put all reasonably practical measures in place to guard against those risks, specifically when we're getting so many instances now across the board.
Thank you very much, Bryn. That's really helpful. I'm afraid I'm going to have to call questions to an end now because we're getting close to 4 p.m. It's time to wrap things up, but can I say please a big thank you to our 3 speakers this afternoon, Andrea Thomas for her overview on furlough changes from the 1st of July and the statutory guidance, Bryn for health and safety guidance and tips, and Chris for his advice regarding the reluctant worker and claims that are likely to arise through the tribunals and mediation and whistleblowing. Thank you to all the attendees for joining today, and thank you for your participation. Be sure to keep monitoring our COVID-19 Hub for regular updates as matters unfold. We've got a plethora of materials and sources and webinars available online to you all for free, and we're updating that as we can, or as close to real time as we can. We'll also follow up in the next few days with answers to your questions, and we will release a recording of this webinar. Please check our events section on the website too for upcoming webinars and other events that you may wish to participate in. And without further ado, I'll say diolch yn fawr. Thank you for participating this afternoon and for your time. And we look forward to engaging with you in the future. Many thanks.